Welcome to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Jackson, Mississippi. His motto is more for you and less for us.
Do you make an opening statement like I see on TV?
Well, as a form of procedure, under most circumstances, you're right, you should have an opening statement. However, municipal courts and justice courts almost always forego those. You usually see a closing statement, but not very often do you see the opening statement that is the shot heard around the courtroom necessarily. Normally what happens is they'll ask everybody if they're ready for trial, and they'll tell the prosecution to call the first witness.
Speaking of witnesses, do you cross-examine?
Absolutely, every time. There is nothing better than picking a law enforcement officer apart on the stand who's charged somebody with a DUI and he can't prove the case. I also cross-examine any witnesses the state wants to call. I always cross-examine without holding back. That's your chance to tear them apart. And the time for being nice passed the second they said, let's go to trial. And they didn't offer you a fair deal or they didn't dismiss it. So at that point, we're at war, and I go and I cross-examine every individual the state wants to put up there.
Do you ever make a motion to dismiss?
Absolutely. Sometimes, depending on the jurisdiction, I might have a relationship with the prosecution. I can just send them some case law, say, pull this file, look at the facts, tell me what you think. And quite often, the prosecutor will call me back and say, Joey, I think you're right. We don't have standing for whatever reason, and they will dismiss it voluntarily. Sometimes I file a motion to dismiss beforehand. Sometimes I make my motion the second I walk in the courtroom. And sometimes something comes out in trial, in which case I will move to dismiss once the prosecution rests because I don't feel like they've met their burden of proof. So there are multiple places to make the motion to dismiss, and quite often I make it.
Does the prosecution ever make rebuttals?
Well, as far as making rebuttals, certainly they have a right to do what's called redirect. So you have direct examination where the officer is called, the prosecutor will directly examine him. I will step up and cross-examine him. And when I step down, they have the opportunity to redirect on anything that was discussed in the cross-examination. So they have the opportunity to try and clean up anything that I might have poked holes into, because that's what I'm doing when a witness is on the stand and my client's sitting there in the hot seat. I'm poking holes into that witness's testimony and credibility. And of course, the prosecution is going to come back and try cleaning that up. And I don't blame them, but my job is to poke a big enough hole that they can't fill it in.
Are you allowed to speak with the prosecutor outside the courtroom?
Absolutely. Quite often, I've talked to them before we ever walk into the courtroom, and we've talked about the evidence in front of us, and we generally have an idea whether or not it's going to go to trial. In the event I haven't had the opportunity to speak to someone beforehand, I will usually meet them in the courtroom, and we'll step away for a moment and discuss the facts and situations and see if there's anything to be negotiated. If there's nothing to be negotiated, then it's got to be tried.
So I guess that takes me to my next question. Can you make a pretrial offer?
Certainly we can. You can go and talk with the prosecutor, and sometimes the prosecutor will defer to the police officers. And that's why I say it's always best to be polite. You can assert your rights in a firm manner and be polite to the officer. They should be understanding of that. If they're not, then that's a whole nother issue. But if you're polite to the officer, that goes a long way, because if they remember that you were mean to them and I go to talk to the officer and say, look, such and such has this going on, can we do this? They may recall that person was really mean to me, or they may recall that person was a pretty decent fella and they just seemed to be trying to get by so we can work something out. And the officer's opinion carries weight with the prosecutor, because the prosecutor works with those officers days in, days out. So he's going to see those officers more regularly than any attorney in the state of Mississippi. So he's always going to put some weight to their opinion and what they would like to do. But yes, you can go and discuss pretrial offers, and quite often things work out before trial. Sometimes they don't, and sometimes it has to go on to trial, or we have to see if we can't handle it some other manner.
Thanks for listening to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Jackson, Mississippi. Call attorney Franks at 601-773-7777. His motto is more for you and less for us.